Moving on to personnel files, as everyone here, I'm sure already knows, employers are required not just under state and federal law to maintain personnel files. Employers should maintain personnel files because it helps keep the employee's information and records organized. State and federal law mandate what information should be kept and for how long. With respect to the personnel file, it used to be 3 years, but the governor, as far as California requirement is concerned, it's now 4 years. So you must maintain the file during the employee's employment and then 4 years from the time they are no longer employed. Not only is, this is a legal requirement, but it's helpful to keep the file because it helps track an employee's data and metrics related to the employee and their employment. In keeping the personnel file, ensuring confidentiality is paramount, as is with all other employee records, but especially true for personnel files. Must be kept in a safe and secure place where it's unlikely to be lost, damaged, or accessed by unauthorized persons. Not everyone should have access to the employee's personnel files, and this is due to the privacy concerns, obviously. So therefore, anyone that has access should be individuals who are absolutely need to know the information in the personnel file. And in addition to keeping the personnel file, employers should always make sure that they have a backup for these files. Next slide, please. What type of records are considered personnel files? An employee's personnel file contains a variety of documents related to directly their job employment and their employment status. Exactly what to include will depend on the employee and the specific job position that the employee holds, but generally certain categories, including employment history, performance, development, and termination, would be the documents that go in the personnel file. In deciding what to put in the personnel file, what else to put in the personnel file, there are several things to keep in mind as an employer. The first thing is perhaps the legal use. You may want to include a document that could be used to defend the company against a lawsuit or in a legal dispute with the employee. However, I would be careful not to include, and as I've listed here, opinions that you think would be helpful in a legal dispute. If it's an opinion, obviously it should not go into the personnel file. When I say that documents that could be used to defend a company against a lawsuit, if you have documentation of performance shortcomings, warnings, verbal warnings, written warnings, those obviously would be helpful in a legal dispute against the employee. So that would be in the personnel file. Anything that's relevant to the employee's role, that relates, anything, however, that relates to medical issues, disabilities, those shouldn't go in the personnel file because that's not relevant to the employee's role. Facts and opinions generally don't go into the personnel file. Facts do. Anything that you think would be safe for the employee to see or an employee's representative to see in the personnel file would be in the personnel file. So notes from investigations, emails between supervisors regarding an employee generally would not go into a personnel file. According to the DLSC, the categories of records are generally considered to be personnel records are those that are used to determine the employee's qualifications for promotion, additional compensation, disciplinary action, or including termination. As I think Pooja or Anthony mentioned earlier, the labor code does not define exactly what goes in the personnel file or what documents are in the personnel file, but the DLSC has given us some guidance in terms of what they consider or what documents they consider to be in the personnel file. Those are obviously employment application, payroll authorization form, notices of condemnations, warnings, disciplines, terminations, notice of layoff, leaves of absence, vacation, education training notices, performance appraisals, reviews, attendance records. The DLSC notes that attendance records goes in the personnel file, but I think in practice, it's probably impractical to maintain attendance records in a personnel file. And we generally don't see that in personnel files, but that's something that DLSC has the opinion that should be in the personnel file. Other things I've listed in addition to what the DLSC has, I've listed specific requirements in this next slide and the one after. I'm not going to go into those in detail, but you can see what other things that can generally be placed in the personnel file.
We will make these slides available, so sorry for moving quickly, but you'll have this list.
Things that may not be kept in the personnel file, and this, reference checks, background checks, if you have an actual background report, that would not go in the personnel file. However, the document, the disclosure forms that the employee may complete to authorize the background check, that would likely be in the personnel file. Child support documents, details about that probably don't belong in the personnel file. Medical records, beneficiary information, time records, records relating to other employees, investigations, and I-9 forms generally shouldn't be in the personnel file. Often employers keep the I-9 forms of all employees stored together in one folder.